Good afternoon. Welcome back to Passionate World Talk Radio Network, a wholly owned subsidiary of Global Media Network, LLC. And today, on this episode of Lest We Forget Historical, we are going to talk about the FTC, which stands for the Federal Trade Commission, and speech, that is, free speech in the United States and outlined in the U.S. Constitution. Lately, there's been an enforcement of how people are speaking in our country. And while you may not affect or feel that you're going to find the effects affecting you, you are potentially wrong. They are going after advertisers and people in the marketing and promotion field, which is PR, and they're also going after small businesses who are trying to get the word out about their business. The problem is how they're doing it and how the FTC is now coming after you when you use these words are something you need to keep in mind and make sure you protect yourself by not saying the wrong thing. So listen up. I went to the Congressional, that's Congressional Research Service, informing the legislative debate since 1914. So I trust what they're saying, and you should too. And the title of their article is False Speech and the First Amendment, Constitutional Limits on Regulating Misinformation. Now, we've heard a lot about misinformation. So federal and state legislatures have expressed an interest in regulating online misinformation and disinformation, and that such regulatory efforts may implicate the U.S. Constitution's First Amendment. The Supreme Court said that the Free Speech Clause protects false speech when viewed as a broad category. But the government may restrict limited subcategories of false speech without violating the First Amendment. For example, defamation, fraud, political advertisements, and broadcast speech are subject to special considerations. And in the focus insights that they present in this article, it highlights some of the relevant constitutional considerations in crafting new regulations of false speech. The First Amendment protection for false speech. The Supreme Court recognized that false statements may not add much value to the marketplace of ideas, and that there is a concern that by prohibiting false speech, the government would also chill more valuable speech, meaning that it would cause people to self-censor out of fear of violating the law. So what does that mean to you? Well, for one thing, the law targets speech based on its expressive content. That content-based regulation will trigger strict security analysis. Under the strict scrutiny, a law is presumptively unconstitutional unless the government can show the challenged law is the least restrictive means of targeting speech while also serving a compelling government interest. However, the Supreme Court has split on the exact level of scrutiny applicable to the small false speech regulation. In the United States versus Alvarez in 2012, the Supreme Court invalidated the Stolen Valor Act, a federal law prohibiting false statements about receiving military decorations or medals. And the 4-justice panel said, quote, that falsity alone may not suffice to bring the speech outside of the First Amendment. And that the Stolen Value Act is a content-based law. And the court held that the law was not sufficiently narrowly tailored. It punished false statements regardless of the context or purpose. And there was no direct causal link showing the law's broad scope was necessary to the government's goal of protecting the integrity of the military commission. So in other words, be very careful what you say because you may not be protected by the law. And also goes on to existing prohibitions on false speech and false statements, but the Supreme Court has historically allowed certain limited characters of speech to be regulated based on their content. And these categories include defamation and fraud, both which entail false speech. And existing federal laws prohibit, for example, perjury or making certain material false statements to government officials. They also have added misrepresentations in political advertising or in the broadcast media. Defamation, in particular, claims can vary by state, but they can also impose liability for making certain false statements, harming a person's reputation if the speaker acting negligently with respect to whether the statement was true. While the Constitution allows a liability for defamation statements, the First Amendment remains relevant in evaluating the standards for providing defamation. In the landmark 1964 case of the New York Times Company versus Sullivan, the Supreme Court ruled that statements about public officials enjoyed heightened constitutional protection from defamation liability. Public officials cannot win in a defamation case unless they show an allegedly defamatory statement was made with malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not. The actual malice standard also extends to defamatory statements about public figures, and lesser constitutional protections apply defamatory statements on matters of public concern. In addition, lower courts have long held that the First Amendment requires a heightened standard before certain speech distributors, such as bookstores, may be held liable for circulating material with defamatory statements. False and fraud commercial speech. The common law of fraud imposes liability on a person who makes a fraudulent misrepresentation for the purpose of inducing someone else to act detrimentally and justifiably in reliance on that material misrepresentation. Federal state governments have also enacted various statutes punishing specific types of fraud. For example, in 1948, the Supreme Court easily rejected a First Amendment challenge to federal laws prohibiting mail fraud. And the court cautioned that government may not avoid First Amendment scrutiny by simply labeling an action one for fraud. The Supreme Court also stated that false or misleading commercial speech may be prohibited. For constitutional purposes, commercial speech is speech that does no more than propose a commercial transaction or that relates solely to the speaker's and audience economic interest. And the FTC and the Federal Commission Communications Commission can regulate deceptive commercial speech without violating the First Amendment. And then they also go into campaign speech. But what should be of particular interest is for those that are involved with broadcast media. Broadcast television and radio are subject to special restrictions. Federal regulations require broadcast stations to identify sponsors of paid content, for example, and prohibit knowingly broadcasting false information about a crime or catastrophe causing substantial public harm. Based on standards requiring license to serve the public interest, the FCC has also said broadcasters may not intentionally distort the news. While the Supreme Court has not specifically considered the constitutionality of these false speech restrictions, the court has long said the First Amendment allows more regulation of broadcast content than any other type of media. At the same time, the federal law instructs the FCC to avoid censorship. You also may want to know that if you want to find out more information about your speech as a PR firm or a small business that are saying something that may be true or false or enlarged beyond its original truthiness, you can go for unprotected speech. You see the CRS in focus, capital I, capital F, 1072, the First Amendment, Categories of Speech by Victoria L. Kingong. And for an explanation of policy considerations related to regulating social media and misinformation, see CRS report, capital R 46662, social media, quote, misinformation and contact moderation, issues for Congress by Jason A. Gallo and Claire Y. Cho. For a discussion of First Amendment concerns related to regulating online contact moderation as well as special treatment of broadcast media, see capital C, capital R, capital S, report, capital R 45650, Free Speech and the Regulation of Social Media Content by Valerie C. Branson. And Valerie C. Branson put together, she's the legislative attorney, and she put together this article. So before you open your mouth or before you do anything with PR, marketing, or promotion, or you're involved with radio or TV, check out what you need in order to protect yourselves from receiving a letter from the FTC saying, "Dear John, you are being sued for ABC 123. Thank you very much for joining us this afternoon. Should you wish to hear this or see this on Lest We Forget Historical, the FTC and Free Speech, go over to https://passionworldtalkradio.com. Scroll down until you come State of Current Affairs. Click on the link. When you get to that page, click on the Google link, and it'll take you right into the Belly of the Beast YouTube, and you can see all the videos on the different episodes of Lest We Forget Historical. This show is sponsored by http:// with Lillian.com. Click on the link. It'll take you to a page. Check out Ruby AI with the demo, and then sign up for $25 a month, the same amount you pay on the other AI, but you get everything you need because it's all in one place. It is no brainer. So check it out. Also by a publishing company based in Singapore that will help you write up and get out your memoirs to the world. Contact us at pwrnetworkllc@gmail.com or text us at 484-364-103 1032. Leave your name, leave your email, leave a phone number, best time to call, and put down memoirs, and we will contact you within 48 to 72 hours. Also, the obstacles of podcast training by someone who's been doing it for the past 19 years. It's for elementary, middle school, high school, junior college, technical school, 4 years, university, continuing adult education. Get your voice and your ideas heard. Go over to https://education.passionalworldtalkradio.com/masterclass and go and see what you can get involved with and get your voice here, verbal and visual. That's the future, along with AI. Thank you very much for listening, and remember, please keep listening. Thank you.